Good afternoon and welcome. Thank you for joining the Office of Court Administration. My name is Hector Gomez and I will be today's moderator. I am the Court Security Director in the Research and Court Services Division at the Office of Court Administration. The Research and Court Services Division moderates a webinar each month, and today's topic is Court Security Committees. Prior to beginning the presentation, I would like to address a few housekeeping details. Please mute your microphone. If you have a question, please utilize the chat box. I will be monitoring the chat box throughout the webinar. If there is a technical question, we will address it immediately. Questions pertaining to the presentation will be addressed at the end of the webinar. The webinar will also be posted along with the PowerPoint on our website. I would like to introduce you today to today's speaker, Judge Karen Crump. Judge Crump was elected as the district judge of the 250th Civil District Court in 2014. Judge Crump currently serves as the chair of the Travis County Courthouse Security Committee. So I would like to welcome you all and welcome especially Judge Crump to this afternoon's webinar. Judge Crump.
Good afternoon, and thank you for having me today. With the hope of trying to assist all the other counties who are working to implement the Judge Julie KOCUREK Judicial Courthouse Security Act of 2017, I'm going to give you a little tour of what we did in order to implement the act in our county, Travis County. So let's just kind of walk through. First, I want to begin with talking about what the act is. The Texas legislature passed the Senate Bill 42 during the 85th legislative session. Governor Abbott signed the act into law on May 27th, 2017, and it became effective on September 1st of that same year. And what does the act do? It expands security incident reporting requirements for court buildings. So it requires all of us to report any incidences in our court buildings. It requires court security officers to receive specialized court security training in their first year. And it allows DPS at their discretion to provide personal security to a state judge who has been threatened or attacked. It also allows for methods to further restrict personal information of current and former judges and tasks the Office of Court Administration with ensuring compliance. It requires that the Office of Court Administration create a judicial security division to serve as a central resource for security best practices, which they have done and which we have through Hector Gomez. And it requires the presiding municipal and administrative judges to create a court security committee for all courts served by that judge. So that takes us to what we're going to talk about in more detail today. Our Court Security Committee composition is set forth in section 74.092A13 of the Act. So if you take a look at that, you'll see that the committee should be comprised of one, your local administrative district judge or his or her designee, who serves as the presiding officer of the committee. In Travis County, the local administrative judge was Judge Laura Livingston, and she appointed Scott Jenkins to serve in that role, which he did for a year. Also, the committee is comprised of a representative of the sheriff's office. In Travis County, our sheriff did actually sit on our committee and still does. Throughout the 18 months that we've been working on implementation, she has also designated someone to attend the Policies and Procedures Subcommittee and has worked closely with me in touring all of our court buildings and helping to make recommendations and implementing those recommendations. We also have a representative of the County Commissioner's Court on the board. Our county judge has attended some of our meetings, but she also has sent in her stead a representative from her office who has attended the meetings as well. And one judge of each type of court in the county other than a municipal judge. And so we have representatives from the district courts, from the county courts, and the JP courts on our committee. We also have a representative of the county attorney's office. It may also be a district attorney's office representative depending on who it is in your county who does the work of really understanding and interpreting laws. In Travis County, our county attorney serves in that role, and so our county attorney has been working very closely with us, and I'll talk a little bit more about that in a few minutes. And also, the Act provides that any other person that the committee determines necessary to assist the committee. And so really that's up to your discretion to include, or it's up to the local administrative judge to include anyone else on the committee who might be helpful in the workings of the committee. For example, county facilities is tremendously helpful. Those are the folks who are implementing changes within the court building. So if you have someone from court facilities to sit on the committee, that may be very helpful to you. So what are the first steps once your committee has been compiled? The first thing that I suggest that you do is to catalog all the buildings that fall under courthouse security and survey the existing security measures and any policies that may exist through the sheriff's office or through the building specific policies through county facilities. Second, consider forming a policies and procedures subcommittee. This was really helpful to our work in Travis County because it was an enormous job and we needed really a smaller committee to do the actual work to make all of this happen. Our subcommittee was comprised of myself, chair of the policies and procedures subcommittee, our sheriff, our county attorney, a representative who was the presiding judge of the criminal county courts, as well as one of our justice of the peace. So with that committee, that smaller committee, we began working on a monthly basis meeting and sort of creating a long-range plan and short-term steps to get to that plan. The very most important document that you want to start with as you are beginning your work, either in your subcommittee or in the committee, is this document, which is entitled Steps to Best Practices for Court Building Security. And I've given you the link of where you can find that. We'll get that to you, or we'll find a way to get it to you. It is a tremendously helpful resource as you're looking for what you should be doing in your county to ensure that your buildings are safe in order to prevent anything from occurring. Let me just give you the 7 most important pieces that you can take from that document. Our county attorney and his office looked very closely at this document and started putting together a chart of these 7 items that you need to be thinking about. What do we need to be doing in each county? We need to, 1, create a lockdown and evacuation procedure for judges' chambers and courtrooms and for all other areas of the court building. 2, designate a floor warden on each floor of your court building to ensure proper response to emergency instructions. Your floor warden may be a sheriff, it may be a deputy, it may be a court operations officer, but you just need to decide who that floor warden is going to be. Number 3, designate a floor warden identified and trained on each floor to respond to medical emergencies. So in addition to active shooter or types of events that you might be thinking about when you're involved in this committee, we also have medical emergencies like cardiopulmonary resuscitation, the use of defibrillators while 911 is called. Who's going to be the person on your floor who's going to tend to those medical emergencies? Number 4, designate a safe area for staff to assemble and remain in place during an emergency or any negative event. Number 5, designate a safe area for a command center during an emergency or a negative event. Number 6, develop methods for notifying judges and employees of emergencies or negative events, including the use of communication warning codes, which I'll talk about in just a second. And finally, develop evacuation plans that everyone in the building has been familiarized with. In our building, we all know exactly where we're supposed to go in the event of an emergency. And after we began this process, we tested that knowledge and made sure that everybody knew where to go. And we learned that even though we thought everybody knew where to go, they were going different locations. And so actually going through the process of ensuring that they do indeed know where to go and when and how. All right, so what next? Once you've reviewed the steps to best practices, you really should take some time to review the existing emergency plans. Are there any in place? And if not, create new ones that follow the steps to best practices for court building security. Make sure you've looked at any countywide emergency response and preparedness plan to make sure that your plans don't conflict in any way with those plans. And look at any building-specific emergency action plans that facilities might have that you may not be aware of. So when you start looking at those proactive guide and planning tools, you want to understand the best practices lays out steps for establishing normal and overall court security policies and practices, but it doesn't get into guidance on emergencies or disaster response, which should be the primary objective of a protective action plan. In Travis County, we have a protective action plan that provides guidance for concerning foreseeable emergencies to all of our employees, our contractors, and any visitors that come to our courthouses. The plan outlines personnel responsibilities, emergency procedures, and proactive plans for reasonably anticipating emergencies, or those that are. And finally, plans should include any means and methods of communication during an emergency. Are you going to use broadcast system? Are you going to use walkie-talkies? How are you going to ensure that all of your employees, your court staff, and your jurors know what to do in the event of an emergency? So warning codes for court buildings have come about since the Columbine disaster, the school shooting that you are probably familiar about. The National Courts National Center for State Courts, as well as professional emergency responders, suggest that communication during an emergency must be clear, understandable, and very simple. So after Columbine, some color codes were developed by a high school administrator in Kansas, and I'm going to talk with you a little bit about those. I'm going to encourage you to implement those into your emergency plan. The color codes were followed by verbal commands and have been widely used in schools and hospitals and universities, as well as in some federal and state courts nationwide. The decision about whether to stay or leave a court building during an emergency can often be the difference between life and death. So following really clear codes, color codes, is incredibly important. So realizing that clear communication is understandable with simple instructions and vital in a court building emergency, think about implementing the following codes. Code red. This means imminent danger. This means an active shooter is in your court building or there is an active hostage situation. Get into an emergency protective posture or in a safe haven pursuant to your predetermined emergency response plan. For example, you run, hide, fight. In our building, we've been trained that if it's code red, you need to run, you need to hide, or you need to fight. One of those three. That is imminent danger. Code orange is evacuate building. Listen to the instructions from your floor warden. That might be the sheriff who's on your floor. It may be your deputy. It may be your bailiff. It may be some other person, but someone needs to be responsible for communicating which code you're at and report to your assigned location away from the court building if you're at code orange. Code yellow that means an emergency team is responding. Or is in the court building. So wait for further instructions from those officials. Code blue means situational awareness. Just be aware and prepared to react to danger. A dangerous situation may be developing in the court building, so be cognizant of what's happening around you. And finally, code green just means that all is well. Return to normal operations. So that's where we obviously always want to be and where we're going to hope to get to before we go back to normal. I wanted to also give you all a timeline of what we did in Travis County and how we did it. I mentioned that Judge Scott Jenkins was the chair of the Travis County Courthouse Security Committee when we started back in fall of 2017. The first thing that he did in his work was to appoint me as the chair of the Policies and Procedures Subcommittee. And that subcommittee was comprised, as I previously mentioned, of myself, Judge Elizabeth Earle, Judge Chu, who's one of our Justice of the Peaces, and the Sheriff, Sally Hernandez, and County Attorney David Escamilla. We began meeting in January of 2018. The very end of that month. So we set our first meeting, March 2018, and then we met again in April, in May, and then we skipped June for summer, and we went right back to work in July. In July, I also set to work with meeting with facilities to find out exactly what work had been done in order to find the deficiencies in security in our building. By happenstance, we had hired, Travis County had hired the company KROLL to do a very detailed report on our security, our lack thereof in certain areas of our building, our civil courts building, in the fall of 2014. So we had that document to work from, and I began working with facilities to go step by step through that about 45-page document to see what had been done and what remained to be done in order to ensure the safety of our building. And so I met closely with the head of facilities and with the head of security for facilities, as well as the court administrator for our civil courts, Peg Lidke, and we just took it step by step. Continued meeting as a subcommittee, and then began implementing specific tours of every one of our court buildings. In Travis County, we have a lot, not as many as you all have in Harris County or Dallas County, but we have a lot of buildings. And so that in and of itself was a large task. We went to the juvenile courts building, and most importantly, we then asked the occupants of the building who had an interest, a security interest, in attending those tours to come along with us and to tell us what their concerns were. What are your security concerns? Because those people who live in those buildings know best where the deficiencies are, and we need to know what those are so that we can address them, and that we can work closely with the sheriff's office to address them, so that we can work closely with facilities to address them. And so we went to our juvenile building, we went to our civil building, we went to our criminal building, we went to each of our 5 JP buildings, and we went tour by tour. Our tours were not only the occupants, but also someone from the sheriff's office who had volunteered to be the expert on best practices. So this particular sheriff, deputy sheriff, had read the best practices, and so he was looking, when we took these tours, really looking to see if we were meeting the requirements or the recommendations from the best practices. And so that was tremendously helpful. We also had somebody from facilities who took copious notes about what was likely to be approved by the committee without having to go through a budget request. So smaller changes that could be made. For example, I'll give you an example. In one of our buildings, we toured an associate judge's office, and the glass window came all the way down to the ground. So anybody who was had finished a hearing could walk right by that judge's window and could actually see into the judge's office and could see that judge there after a hearing, which could be very contentious. One of the first things that we were able to do and do within our existing budget without having to ask for a budget change was to put a dark screen on that window, so at least people who were leaving a contentious court hearing couldn't see the judge who had potentially ruled against that person. So that was one quick thing that could happen just immediately following the tour. We continued doing those tours all the way through the end of 2018. It took a while to get through all those tours, and but we did. And so I wanted just to give you an example. I actually solicited that the occupants send to me their concerns. And so I just kind of gave you a little example here of what those looked like. So for example, Chief Medina, who is our chief juvenile probation officer, she sent me a list of what her concerns were. I've redacted those here because I don't want those to be out in the open, but she kind of just walked through what her concerns were, and really acknowledging how important this process is for them, because for many of these occupants, they've been sort of living with these things that worry them, that concern them, but nothing's really been done about them. So just hearing their concerns and walking through them and trying to get those concerns addressed was a really important process. I wanted also to show you, we toured the 4D courts. The 4D courts are kind of a strange hybrid, as you all probably know. In Travis County, our 4D child support court is not in our main building. It's in a state office, and so sort of outside the county's umbrella. And so instead of waiting for the state to make changes, we went ahead and took, that court under our county wing, because they're doing the work of our courts, they're doing the work certainly of our civil district courts, and we really want to make sure they're safe. And so I also asked those 40 judges to send us their concerns, and immediately had the sheriff's office take a look at those concerns and concur. The sheriff's office concurred with all of those concerns, and we got those addressed very quickly. I wanted to show you what the the KROLL report recommendations, that what they look like and how we tackled them. I mentioned that we did a report in Travis County on our civil court building back in the fall of 2014. And when I sat down with our facilities group to find out what had been addressed in those recommendations, we went line by line, and this is kind of what it looked like. And I can show you the ones that have been completed, but you may recognize some of these concerns at your own courthouses. Number one, the KROLL report recommended that you eliminate all signage bearing judges' names. In fact, anything that would show that you're a judge should be removed immediately. In front of our civil court, we have open parking. We don't have secure parking for our civil building. We do have it for our criminal building, but we don't in some of our other court buildings. And so make sure that there's no signage with your names out there. You just don't want to make it any easier for the bad guy or gal to know where you park. I'm not going to go through each of these, but just wanted to show you some examples of what those recommendations might look like if and when you or your county hires an engineer to go through and make recommendations. This is what they might look like. Make sure that the kitchen staff's not propping doors open. Make sure that your door hardware is intact and that there's not nails missing. Make sure that that your card readers are working if you have card readers. Here's some examples of electrical recommendations that the engineers from KROLL provided to us. Make sure that every bench has a duress button, so that if there is an emergency, if your hearing is becoming very contentious, that you can push that button and that someone's going to come to your rescue as quickly as possible. Those duress buttons are really important, and there should be a recommendation that every bench in Travis, throughout the state, should have a duress button, so that if something is escalating either between litigants, between you and the litigant, or somewhere in your immediate vicinity, that you can notify people immediately. And then, I did show that, perhaps a judge might decide they don't want that duress button. And so we have a line there just to show that that particular judge rejected the duress button for whatever reason. And, just because the recommendations are made doesn't necessarily mean that they have to be done. Operational recommendations look like, what's your day-to-day protocol for security? Do you have a security officer after hours? If people are coming in and out of your courthouse building, you should have somebody who's monitoring, because you can be really safe Monday through Friday, but if you leave your court building open, or people can come and go as they please, you might have some vulnerability there. One of the things that you as a county need to consider is, are you going to be 100% screening or some variation thereof? In Travis County, we actually have a variation. Our criminal court building is not 100% screening. Our civil court building is 100% screening. And so just making some decisions for whatever works for your county based on the security that you have in other forms. Just have to make those decisions and make them deliberatively based on the resources that you have and on what's available to keep you and your court occupants safe. Just some other operational recommendations and what those look like. Just wanted you all to see what had been recommended to us. We're in an 80-year-old building in our civil court, so it is old. And so it had a lot of problems and a lot of vulnerabilities, and you'll kind of get an idea of what they recommended and what we actually did to address those recommendations. Once you've toured your buildings, you've really put your arms around the best practices for your county, you should be creating a county-specific security policy. And this is ours. One of the things that was very important to us was to have buy-in for all of the people who are not only occupants, but are responsible for security for each of the buildings. So I have there at the front, you'll kind of see how I broke it down by building. I wanted to make sure that each sheriff, constable, anybody who was responsible for security was approved this policy. Every elected official responsible for the building also approved this policy. And then we wound up having the entire committee that was impaneled vote to approve this policy. So this is what ours looks like. It just sets forth that this has been done under the Julie KOCUREK Judicial and Courthouse Security Act of 17, and that we are responsible for adopting security policies and procedures for all of our court buildings. And then it outlines at the bottom there the things that are mandatory under the Act. You must ensure that there's bailiff training, and you must be doing incident reporting. The second page, is what we collectively as a committee decided should also be included in our policy. One, we determined that there should be a thorough screening process to ensure all who enter the courthouse are free of prohibited weapons, contraband, or any item deemed a security threat unless that person has been designated by written policy as someone with authority to do so. And the screening policy needed to include procedures for confiscation, seizure, and removal. And so whatever your policy is that's right for your county, it just should also be, it should be set forth in a policy that you need to create. Number two, operational. And for Travis County, we have established procedures that set forth general duties and responsibilities of our courthouse personnel, including bailiffs assigned to security that include alarms and camera monitoring, personnel access control, including any keys and badges. Do you know where all those are? Do you know who has access to those? Automated door control, system programming, security rounds, who's doing the morning sweeps to ensure that no one's left a gun in any of your courtrooms. Just making sure that there's a policy that is in place that has whatever those rounds are going to be. Courtroom inspection, who's doing the courtroom inspection and who's doing after hours courthouse access, who has access and when and why. Next is training manuals. Establish training standards and requirements for all security personnel based on the individual's duties and responsibilities. And what are your emergency protocols? We talked a little bit about that, but you know, making sure that at least the following three: having procedures for emergency situations, including active shooters, bomb threats, fire, and any other security threat. Providing instructions for lockdown and evacuation, designating a floor warden, designating a safe area for command center. How are you going to notify judges and employees in emergencies, including and incorporating in those communication warning codes, providing an evacuation plan for all court building occupants, and finally providing a location that emergency equipment to be used by facility staff and emergency responders. I also put in there, we put in there a news media protocol because for most of our hearings, we don't allow photographs and video in our courtroom. But we do have a policy in place that if news media wants to film, they just need to ask in advance. That way we can say no cameras, no videos, unless there's a prior approval from the court administrator's office. And finally, the recording protocol itself, just establishing a policy that the public's made aware of for proper and improper use of cameras, cell phones, and recording devices within the facilities and the courthouse. So once we put our policy in place, we next are looking ahead to creating a task force for each building, because each building is specific and each building has nuances and each building has its own vulnerabilities. We believe that each building should have its own task force. And so who are the elected officials who have offices in that building? Make sure that they're included. Make sure you're including your sheriff's department representative, and make sure that you have someone from facilities who can make those decisions about changes to your buildings. One of the things you might be thinking about is, well, there's a lot of, that's asking a lot, and it probably is going to cost a lot of money, and that may be true. Section 74.092B provides that a court security committee may recommend to the county commissioner's court the use of resources and expenditures of money for courthouse security, but we may not direct the assignment of those resources or the expenditure of those funds. So in other words, we collectively can make recommendations to county commissioners and say, look, these are the things that we need to keep our courts and our court visitors and our court staff safe. So we make those recommendations, and they have to determine whether or not those funds should be spent on court security. And so, you know, you have empaneled, hopefully, this committee that has a lot of the folks who are very important in making decisions. And so you've got a lot of voices to help you and help support you in making those recommendations and ensuring that these things happen. So I just wanted to provide you all also with my contact information in case you have any questions about how we did it, how to do it, things that we encountered during this process. And I'm happy to answer any questions either now or later if you have any questions as you're getting started.
Thank you, Judge Crump. I do have one question. I get this. This is Hector Gomez, Court Security. This is one question I frequently get out in the field concerning court security committees. And it specifically addresses any issues you may have encountered regarding Open Meetings Act. Can you address that? Are you familiar with
Yes.
those nuances?
Yes, I can tell you a little bit. Our county attorney would probably be better to answer that question. However, that was one of the first questions that we had. There has to be a balance of ensuring the security of the information that we're sharing and also staying in compliance with Open Records Act. Our county attorney determined, based on some research, that security related issues need not be disclosed. And, you know, I want to make sure that all of you talk to your county attorney's office and work closely with them and find out what you need to be doing to stay in compliance with the law. But I know there exists some, I don't have any of the, I don't have the statute in front of me, but I can tell you that those items that provide for security are not subject to disclosures, and you need not include members of the public in those situations where topics of security are discussed. And so if you're going to be discussing some details about deficient or court security, then I think you're probably going to need to work closely with your county attorney's office to make sure that you're not in a situation where you're disclosing any information that could be problematic. You do, however, need to make sure that you are notifying the public of these meetings. And so, make sure that you're in compliance with us. Just work closely with the county attorney's office to ensure that you're in compliance with both the Open Records Act and any requirements for public information.
Thank you. We've got another question from the audience. Is there a preset determination to meet your court security to meet? Is it very flexible, or should it be somewhat on a standard schedule?
I think it should be on a standard schedule. We always scheduled our monthly, our subcommittees meetings were scheduled before we left the room and on a monthly basis. The schedules of the people on our subcommittee were so difficult and so busy. I mean, we had the sheriff, the county attorney, judges. So we always brought our calendar to our meetings, and we always scheduled before we left. And it's hard. It's hard to get everyone's schedule on the same page, but I think you need to make those meetings monthly, at least in the beginning, until everybody has their marching orders. At our first meeting, or one of our first or second or third subcommittee meetings, we decided that the county attorney was going to become the expert on the steps to best practices. One of our subcommittee members was going to be the expert on the criminal courts, and I was going to be the expert on court building tours and the civil court, and our sheriff was going to review all of her existing policies and make sure that they didn't need to be refreshed. So once you have your marching orders, that gets used from month to month, but making sure that you have your calendars ready and that you're able to schedule those meetings with everybody in the room. I think it's important to have those regularly scheduled.
Thank you. We've got a question, or more of a, let me see here. It's, do we have a starting point or a template or a plan for a county to begin their policies and procedures? OCA does maintain a generic form that we've actually worked on with a local municipality. It's a very good template to start your policy and procedures document. You can build onto it and layer any specifics you want to add on to it, like active shooters, any kind of plans that you want to layer on the bottom, bomb threats, etc. So we do have that available. Just reach out to us via email, and we'll be more than happy to provide that to you. Also, the Court Security Committee should be aware of, and at least make it a point to mention, I certainly would encourage for the law enforcement component, specifically addressing them, to remember their requirement to report incidents to OCA within 3 days of an incident, and to render a report and provide it to the judges. I can tell you from my experience working out in the field, we have a severe underreporting problem in Texas. And I think, to try to get the reporting mechanism correct on our end, and of course, for the law enforcement components to practice reporting an incident, it is subjective. So we certainly rely on the county to make that determination, that law enforcement official to make that determination when to report an incident. But the end game is, as we can show the authorities that incident reporting is increasing, then we can certainly address in the form of grants or funding, hopefully in the big picture at the local level, to try to get the necessary funds to, again, these counties that are deficient with x-ray machines, magnetometers, and things of that nature. Another question, do you have a suggestion for very small courts where a larger threat is that everyone knows, no, I can't really get that one.
Sure, it says, the question posed by the audience, do you have suggestions for very small courts where a larger threat is that everyone knows everyone, so no one is really viewed as a threat?
I think that is challenging. I will say this, I looked very closely at the incident reports from our county, and I'll say that we had incidences involving attorneys. I believe there were 4 different incidences involving attorneys within the preceding 2 years. And that means that our deputies had actually caught a weapon of some sort coming into the courthouse and reported it. So as Hector mentioned, one, that means that's just who got caught and that's just who reported it. And these are people we know, these are lawyers who practice. So it's going to happen. It may happen that it's even somebody you're very familiar with who has their own court case pending that day instead of someone else's court case pending. I think every county is different and every situation is different. And so you just have to decide what's right for your county. And that means collectively with the other folks on the committee deciding, do we want to have 100% screening? Do we want to stop everybody? Because we know everybody, but the best and safest thing to do is to follow the steps to best practices and have 100% screening. I can't say what's best for every county, but that's what the National Center for State Courts tells us is the safest. It's the only way to ensure that guns and weapons and other contraband don't come into your courthouse, no matter how well you know them. They may be just having a really, really bad day. And they may be currently experiencing some mental health issues. They might be, as everybody knows, just going through a really, really bad time in their life where they're more tempted to bring weapons into the courthouse and to direct them at somebody who's actually taking action in their particular case.
We had a question from a member of the audience asking about about municipal courts, and are they part of the court security regulations, SB 42?
They are, but they're not in the same part of the act. They're actually set forth separately in the act, and that's why the portion of the act that I read in the beginning to you all excludes them specifically, just because they should be doing their own, and they are mandated to do the same work that we're doing, but just separately.
Another question, do you have any suggestions on where to look at grants as opposed to using court security funds exclusively?
No, I think it's a great idea. I don't know where you could go for those types of funds. I have not encountered any grants available. Hopefully, Hector, you will come across that. That would be great.
I've been referred to the National Center for State Courts as a possibility, certainly an entity to explore. Certainly give them a call. Certainly it's worth the effort to go and make a call, see if they may have some funds available for you. Okay, we have a webinar evaluation at the end of this presentation. We encourage you to fill that out and give us your input. It will also contain, or rather, let me just remind you that this webinar, as well as a PowerPoint, will be provided on our OCA website. Again, we'd like to thank Judge Crump for taking a little time from her busy schedule to provide our audience with this much needed and important lesson on court security committees.
It was my pleasure. Thank you for having me.
Thank you, Judge. Thursday next week, our next webinar, we will feature a comprehensive look at SB 42, drilling down to concerns with license to carry, purchasing a new firearm, incident reporting, suggested no-cost policy changes, etc., and a host of other information that we hope you will find beneficial as we continue the court security discussion. And thank you to our audience for your attendance, and we look forward to seeing you next week. Have a good day.